Thank you for visiting my channel. Before we start, please hit the subscribe, like, and share buttons to receive notification of future presentations. I wish to discuss the topic of presumptions on survivorship under Article 43 of the new Civil Code because this is included in the bar syllabus for Civil Law 1. First, let us consider this scenario. A and B, father and son, died on the same day, but the exact hours of their death cannot be ascertained. Then it is presumed that they died at the same time, and there shall be no transmission of rights, one in favor of another. However, if it can be established that the father died ahead of the son, then the son can inherit from the father. But since the son is himself dead, his heirs can inherit by representation. Here is Article 43 that provides for the rules on presumption. Article 43. If there is a doubt as between two or more persons who are called to succeed each other as to which of them died first, whoever alleges the death of one prior to the other shall prove the same. In the absence of proof, it is presumed that they died at the same time, and there shall be no transmission of rights from one to the other. Take note that Article 43 applies only when the case involves two or more persons who are called to succeed each other, like a father and son. In all other cases, the rules of court will apply. We will discuss this shortly. There must be a showing that there is death by positive evidence. However, it can be done by mere circumstantial evidence. In Joaquin versus Navarro, 93 Philippines 257, where the death of the mother and her son occurred during the massacre of civilians in February 1945 and at the time when Manila was being bombarded during the war, the Supreme Court upheld the ruling of the trial court that, from the evidence presented, the son died ahead of the mother. Article 43 is applicable only in a situation where two persons are called upon to succeed each other, like in the case of Navarro, where the issue was who died first, the mother or the son. Article 43 of the new Civil Code is copied under the revised rules of court and is referred to as Rule 131 Section 5 KK. Immediately preceding it is Rule 131 Section 5 JJ, which reads as follows. When two persons perish in the same calamity, such as a wreck, battle, or conflagration, and it is not shown who died first, and there are no particular circumstances from which it can be inferred, the survivorship is presumed from the probabilities resulting from the strength and age of the sexes according to the following rules. A. If both were under the age of 15 years, the older is presumed to have survived. B. If both were above the age of 60, the younger is presumed to have survived. C. If one be under 15 and the other above 60, the former is presumed to have survived. D. If both be over 15 and under 60 and the sexes be different, the male is presumed to have survived. If the sexes be the same, then the older. And E. If one be under 15 or over 60 and the other between those ages, the latter is presumed to have survived. Take note, however, that Article 43 and the rules of court presumptions on survivorship are not applicable when there are facts, known or knowable, from which a contrary conclusion can be inferred. In such a case, the rule of preponderance of evidence controls. Here is a summary of the case of Ramon Joaquin versus Antonio C. Navarro, 93 Philippines 257. Facts of the case. On February 6, 1945, while the battle against the Japanese in Manila was raging, the family of Joaquin Navarro Sr., 70, and Angela Joaquin de Navarro, 67, sought refuge in the ground floor of the building now known as German Club. The family was composed of the spouses Joaquin Sr. and Angela, their son Joaquin Jr., 30, and the latter's wife Adela Conde, and daughters Pilar, 32 to 33 years old, and Concepcion, 23 to 25 years old. With them was a neighbor named Francisco Lopez. The building was set on fire, and the Japanese shot the daughters who fell. Joaquin Sr., Joaquin Jr., and his wife Adela and Lopez decided to leave the building to seek refuge elsewhere, but Angela refused to go with them and was left behind. As they came out of the building, Joaquin Jr. was hit and fell. The rest lay flat on the ground to avoid gunfire. Meanwhile, German club collapsed, trapping the people inside, presumably including Angela. The trio, Joaquin Sr., Adela, and Lopez, sought refuge in an air shelter. On February 10, 1945, Joaquin Sr. and Adela were killed by Japanese patrol. Lopez survived to tell the story. The trial court ruled that the mother outlived her son, but the Court of Appeals ruled that the son outlived the mother. If the mother died first, Joaquin Jr.'s son by his first marriage would inherit by representation, but if Joaquin Jr. died first, Angela's acknowledged natural child and adopted child of the deceased spouses would inherit. The issues are the order of death between mother and son and whether or not the presumptions under Article 43 New Civil Code in relation to Rule 131 Section 5 JJ and KK are applicable. Held. In light of the conditions narrated by Francisco Lopez, a fair inference can be arrived at that Joaquin Jr. died before his mother. The presumption that Angela Navarro died before her son was based on speculations, not evidence. Gauged by the doctrine of preponderance of evidence by which civil cases are decided, this inference that Joaquin Jr. died before his mother should prevail. Evidence of survivorship may be direct, indirect, circumstantial, or inferential. If you find this presentation helpful, please hit the subscribe, like, and share buttons to receive notification of future presentations. Thank you.